The Chancery Court for Davidson County will now transact the business for which it was created. All persons having business before this court draw near, give attention, and you shall be heard. God save the United States, the state of Tennessee, and this honorable court. Criminal Court Judge Sandra Donaghy, Chancellor Casey Culbreth, and Chancellor Patricia Head Moskal presiding.
Thank you. And again, good morning. We are here this morning for a status conference in a 3-judge panel case assigned by the Tennessee Supreme Court. I would like to announce the 3 judges serving today. I'm Chancellor Pat Moskal, serving the 20th Judicial District in Davidson County, where this lawsuit was filed. Joining me on the panel are Judge Sandra Donaghy, serving the 10th Judicial District in Bradley, McMinn, Monroe, and Polk counties, and representing the Eastern Division of Tennessee, and Chancellor Casey Culbreth, serving the 25th Judicial District in Fayette, Hardeman, Lauderdale, McNairy, and Tipton counties, and representing the Western Division of Tennessee. Today is May the 8th, 2025. The case called for hearing is case number 23-1196. The style of the case has been updated to Allyson, Phillips versus the state of Tennessee et al. It was formerly styled as Nicole Blackman versus the state of Tennessee. I want to let everyone know that this status conference today is being live streamed at the request of a member of the public on the Administrative Office of the Courts, Tennessee Courts YouTube channel. I am going to now request that one of the counsel for the plaintiffs, please introduce who is participating today on behalf of the plaintiffs.
Good morning, Your Honor. Linda Goldstein from the Center for Reproductive Rights, representing the plaintiffs, and I am accompanied by Mr. Tift and Mr. Lawrence.
Thank you. And for the defendants, state of Tennessee.
Good morning, Your Honor. Stephen Griffin here on behalf of the state. I'm joined today by Reed Smith, Jacob Durst, Andrew Grams, and Jessica Burke, all from the AG's office.
All right, thank you. The purpose of today's hearing is at the defendant's request. We have scheduled this status conference, which was prompted by the filing of the passage of Senate Bill 1004, which I believe has now been assigned a public chapter number 217. So that would be 2025 Tennessee Public Chapter number 217, effective April the 17th, 2025. And so I will turn first to how we're going to proceed today. I will turn first to defendants counsel and invite you to share what your request is through this status conference, and then we will hear from plaintiffs counsel. We will then allow the state to have a short rebuttal. You may proceed, Mr. Griffin.
Thank you, Your Honor, and we appreciate the court entertaining our request for a status conference in this case, given the intervening change of the law. And we think that SB 1004 dramatically changes the posture of the case as it's currently pled. The new law adds definitions to the abortion statute to help folks interpret and apply the medical necessity exception. And the law now in large part mirrors the temporary injunction order that was previously issued by this court by providing specific examples of medical conditions where abortion would be permitted. That includes PPROM, severe preeclampsia, cervical insufficiency, Muir syndrome, and conditions that would threaten a woman's fertility. As it's currently pled, the second amended complaint addresses concerns with the application of the law as it previously existed. That's a law that no longer exists. There's no plausible allegations in the operative complaint that the current statute denies abortions where a mother's life or fertility are in jeopardy, or where there exists grave threats to a woman's health, like those that were set forth in the court's temporary injunction order, and they're now specifically listed in the statute. We also think it would be purely speculative, Your Honors, for any of the plaintiffs to say that they would have still been denied the abortions that they say they needed if the current law had been in effect at that time. There's also nothing in the current operative complaint indicating a credible threat of prosecution under the 2025 amendment to the statute. In fact, there's no allegations that any of the listed defendants enforced the law against anyone under the last two versions of the statute, much less that there's any credible threat of enforcement under the new statute that now largely mirrors this court's temporary injunction order. All that to say, we think that SB 1004 dramatically changes the calculus in this case with respect to the court's subject matter jurisdiction. That includes issues related to standing, sovereign immunity, ripeness of the claims that are asserted, but also asks the merits. We reached out to plaintiffs' counsel as soon as the legislature adopted the law, and we let them know that we wouldn't be opposed to an amendment to the complaint given the circumstances. Plaintiffs' counsel advised that since then that they have no intention to amend the complaint, and so we're not really sure exactly what their legal theories are with respect to the new law. And what they've told us, Your Honor, is that that they plan to hash that out through their expert reports and in other discovery. We think that turns the pleading standards on their head and is improper. But Your Honors, if the plaintiffs in fact do not intend to amend their complaint, we do intend to proceed with the Rule 12 motion for judgment on the pleadings. We think we can have that ready to file early next week. And we also think that the adoption of this law changes things with respect to discovery in this case. We don't think it makes a whole lot of sense to proceed with discovery on a law regarding the interpretation or the application of a law that no longer exists. So far, discovery in this case has proven to be extraordinarily burdensome, at least on the defendants. We've already gathered, we had to collect and review thousands and thousands of documents. We've already produced more than 10,000 pages of records, and still have thousands more to review and to produce if necessary. That's included discovery propounded to 20 separate state government defendants. The plaintiffs have served subpoenas on the Tennessee governor's office, the legislature, the State Department of Health. And Your Honor, we can already tell from how things have gone so far that there are likely going to be significant discovery disputes that this court is going to have to address. And that's going to go to issues pertaining to relevance.
And this is Chancellor Pat Moskal. Excuse me for interrupting, but we're not here to address any discovery issues today.
Sure.
Other than in the context of your request to have this status conference and your intent to proceed with the Rule 12 motion. So let's try and focus in on that. Prejudice, through extensive discovery is not really a consideration, is it, at this juncture?
Well, Your Honor, one of the things that we intend to raise in our Rule 12 motion, assuming the plaintiffs don't amend their complaint, is a lack of jurisdiction that includes sovereign immunity. And of course, sovereign immunity is immunity as to suit, not just as to liability. And having to go forward with burdensome discovery when the court lacks jurisdiction and when the public servants that have been sued here are entitled to sovereign immunity would effectively deny sovereign immunity itself. And we think that the adoption of SB 1004 does change the calculus with sovereign immunity, even though the court has addressed arguments related to that issue before. The reason that I brought up the discovery issues is because the discovery that we've done so far has proven to be very burdensome. There have been privilege issues that have been raised. We anticipate those are going to be having to be brought before this court, dealing with legislative immunity, deliberative process privilege, attorney-client privilege, relevance, and that sort of thing. In other words, there's a lot left to do. There's going to be a lot of discovery disputes that we end up having to litigate before this court. But that it doesn't make a lot of sense to us to proceed with discovery when we don't know exactly what the plaintiff's theories are under the new law. We're not sure what discovery. We've been doing discovery related to the application of a law that no longer exists. And we don't think it makes sense to do that while a Rule 12 motion is pending. So we're here today before the court, really asking for the court's guidance. Number one, if the plaintiffs are not going to amend, to set up a briefing schedule for our Rule 12 motion for judgment on the pleadings, and then to discuss any implications that would have for the current deadlines for discovery. We have expert deadlines coming up. The plaintiff's expert deadline is later this month. The defendant's expert deadline is toward the end of June. And the discovery deadline in this case is the end of September. And so with the new law, those developments, our forthcoming Rule 12 motion for judgment on the pleadings, we're really asking for the court's guidance as far as how to proceed, any implications for scheduling, that sort of thing.
All right, anything else, Mr. Griffin?
Not at this time, Your Honor.
I have one question, and then I will see if the other panel members have any questions. You have referred a couple of times to Public Chapter 217 as being a new law, and the prior law no longer exists. But I want to make sure I understand what your position is. This provision amends the a couple of sections of Tennessee Code annotated 3915-213A, and so it's an amendment to the prior law. It doesn't totally replace, it doesn't delete and replace the prior.
That's
law,
correct. And the reason that we framed it that way is because the claims in the Second Amendment complaint all go to the application of the medical exception as it was written in the 2023 version of the law.
Necessity exception.
Correct. And the amendment to the law does not address the mental health exclusion. And that's a new claim that was raised in the Second Amendment complaint that has not yet been addressed by the court. But to the extent that the other claims all go to the medical necessity exception and the plaintiff's allegations that they are unable to, that they've been unable to obtain abortions that they claim are necessary because of purported vagueness in the statutory language. That statutory language has significantly changed and now largely mirrors the temporary injunction order issued by this court that this court ruled was necessary to protect the plaintiffs while the litigation proceeds. And so we think that you're correct, Your Honor, the law has not been repealed, but the law that was challenged in the Second Amendment complaint is no longer the law that exists today.
All right, and just for clarity, our ruling on the temporary injunction was an interlocutory ruling. It was not on the merits of the case. It is not a final judgment. And it was a temporary ruling during the pendency of this action. So just to clarify, to make sure we're all on the same page there. Anything else that you would like to add?
Happy to answer any further questions, Your Honor.
Okay, and you'll have an opportunity on rebuttal. Let me turn to the panel members. Judge Donaghy, do you have any questions for Attorney General
No questions
Griffin?
at this time.
All right. Chancellor Colbert.
My question
questions?
really involves more of some logistics, not necessarily the merits question. When you say that your Rule 12 motion can be filed early next week, are you anticipating that to be a hard deadline, Mr. Griffin? Obviously, the concern that I have is that we have a scheduling order, and my assumption is if this doesn't get filed and there's not a response very quickly, we're going to have issue after issue after issue if we get to the merits of this case. So when are you anticipating this to be filed?
Thank you, Your Honor. We anticipate having our Rule 12 motion ready to file early next week. We could probably have it ready by Tuesday.
There we go.
If the court wants to set a deadline, we're fine with that. We think we can have it ready by then. And we anticipate also filing with that a motion to address the current scheduling order.
That was going to be my follow-up, so thank you.
Yes, Your Honor.
All right, if there's no other questions, I will turn to Attorney Goldstein for the plaintiff's response.
Thank you, Your Honor, and good morning, everybody. We've heard quite a bit about what the defendants think the amendment might mean, but we haven't heard very much about the actual text of the amendment. So I'd like to spend a few minutes on that. Just to refresh the panel's recollection, our challenge to 39-15-213 challenges the statute on three constitutional grounds. One is the right to life of pregnant women experiencing pregnancy complications or high-risk pregnancies. Two is equal protection under law for pregnant women facing medical emergencies or who need emergency medical care. And three is the ambiguity of the statute on an as-applied basis. And our ambiguity argument rested on multiple aspects of the law. It rested certainly on the ambiguity of the phrase serious risk of substantial and irreversible impairment of a major bodily function. It also rested on the failure of the statute to identify when medical care could be provided, and a number of other critical issues, such as the reasonable medical judgment standard, which we submit is ambiguous and unduly subjects physicians to criminal prosecution for providing medical care that they in good faith think is necessary to save the life or preserve the health of the patient. All that the amendment does is address one part of the statute. It adds a definition of serious risk of substantial and irreversible impairment of a major bodily function. And that in turn, and I'll read the definition, means any medically diagnosed condition that so complicates the pregnancy of a woman as to directly or indirectly cause the substantial and irreversible impairment of a major bodily function. I'll just stop right there. Just from my reading that, you can hear that that is circular, that it's defining serious risk of substantial and irreversible impairment of a major bodily function by incorporating the term substantial and irreversible impairment of a major bodily function. It also, when you read that definition, when you insert that definition into the original text of 39-15-213 C1A, you get this sentence, that the medical necessity exception applies when the physician determined, using reasonable medical judgment based upon the facts known to the physician at the time, that the abortion was necessary to prevent the death of the pregnant woman or to prevent any medically diagnosed condition that so complicates the pregnancy of the woman as to directly or indirectly cause the substantial and irreversible impairment of a major bodily function. That is no less ambiguous than the original statute. And in fact, we would submit that it compounds the ambiguity of the original statute, because to fall within the health aspect of this, not the preventing the death aspect, the care has to be done to prevent any medically diagnosed condition. And if you've prevented the condition, it can't be diagnosed. So it really is unintelligible, to put it charitably. So that's one problem, an added problem with this amendment, which we would spell out in greater detail in our expert and other discovery, as Mr. Griffin mentioned. Another aspect of the amendment is that it specifies 5 conditions. And these are not conditions that are set out as falling within the medical necessity exception once they're diagnosed. These are 5 conditions that only may fall within the medical necessity exception if they are diagnosed. And we submitted in our written response to the panel the legislative history of the amendment, showing that the proponents of this amendment did not believe that the diagnosis of these elements, of these conditions, would automatically fall within the medical necessity exception. It was just the first step, to use their words. And the second step would be that the physician would still have to find, as he does or he or she does in the original pre-amendment statute, that there was a serious risk of a substantial and irreversible impairment of a major bodily function. So therefore, nothing has changed. Even when a patient presents with any of those 5 conditions, the physician still has to make the finding or the determination that the physician had to make under the original statute. So there is no change in the statute that is material to the claims that the plaintiffs have alleged in this case. And just to spell out, the court has, upheld each of those claims. And
Purposes of the temporary injunction.
well, and
Again,
the motion, yes, and the motion to
I
dismiss.
emphasize that.
And the motion to dismiss. And I'll also emphasize that when the court denied the defendant's motion to dismiss with respect to our right to life claim, it did so by invoking the myriad of conditions that plaintiffs allege in this case are eligible for treatment under the medical necessity exception, where they are, where care is being denied. So it's not just the 5 conditions that are listed in this amendment and which themselves don't automatically entitle physicians to perform or patients to get abortion care. So in our view, the amendment does nothing for either the right to life claim or the unconstitutional vagueness claim, and it doesn't even purport to do anything for the equal protection claim, because it doesn't do anything to address the fundamental argument that the statute, by imposing any kind of barrier to a pregnant woman getting emergency medical care that is needed, that those women are being treated differently from non-pregnant women who need emergency medical care. And so the statute, the amendment to the statute does nothing for that claim. Now, defendants are obviously free to make their arguments as to how they think this amendment affects the claims that plaintiffs have brought, but there's a time and place for that. And the time and place for that is already built into the scheduling order. Discovery will close on October 1. Defendants can make their motion for summary judgment on October 29, and they can spell out at that point what they think the impact of the statute is on the claims, and the court will have the benefit at that point of a fully developed record with reports, deposition testimony from both sides' experts, with deposition testimony from the physician plaintiffs and the patient plaintiffs, assuming defendants take those depositions. So the court will be in a much better position to decide those issues. One thing that I have not heard defendants say is that hearing the motion now would have any impact on the scope of discovery. We don't think it can have any impact on the scope. For one thing, as I started with, we don't think that there is any prospect of success on a Rule 12 motion based on an amendment that merely tweaks the statute by adding an inconsequential definition. I also heard Mr. Griffin address the issue of sovereign immunity. As the court will recall, the court held that sovereign immunity was waived under the statute that authorizes suits against the state for actions seeking declaratory or injunctive relief based on the alleged constitutionality of a state statute. That analysis has not changed. Sovereign immunity was also waived under the Colonial Pipeline decision. That also has not changed. Defendants did not appeal, although they could have taken an interlocutory appeal of the ruling that sovereign immunity had been waived. And so there really is no substantial argument, and certainly other than saying that the amendment has an impact on the sovereign immunity analysis. I haven't seen anything in defendants' motion or in the argument that they made today would suggest that there is any impact. Nor is there anything.
And of course, I'm sorry to interrupt again. This is Chancellor Moskal. We're not here to argue the merits of the motion that has not yet been made. We're trying to focus today, and I understand your arguments go to the motion is not necessary at this juncture, even though the defendants are free to make whatever motion they can during the course of this action, and they're requesting the court's guidance and assistance in trying to schedule and manage the proceedings. So if I could ask you to address, if we were to proceed with a Rule 12 motion at this juncture, which the motions that they're discussing are still permitted under Rule 12.08 and are not waived defenses, Tennessee Rule of Civil Procedure 12.08. What is your position about timing and the impact on discovery?
Well, our position on the impact on discovery is that discovery should continue during the pendency of the motion.
Okay.
There is no basis for holding it up. We have a fairly tight schedule. We have a 2 weeks trial scheduled to start less than a year from today. So there's a lot of work to be done between now and then, and staying discovery would certainly jeopardize that trial date. So there's no reason for that, and we would submit no basis for that. In terms of the briefing, I'll just note that our expert reports are due on the 21st of this month, so it would be somewhat burdensome for us to be simultaneously responding to what we think is a meritless motion and preparing those reports simultaneously.
So what does that lead you to if the court were to proceed with, whatever motion that they file? What are you requesting? The court is not in position to prevent the state from filing whatever motion it deems it is wanting to present to the court at this juncture. But under the, in light of the scheduling order, if a motion were to be filed next week, when would you anticipate that you would be able to file a response?
We don't anticipate that we'd be able to file a response before late June.
Late June?
Yes.
All right. Okay. And I did interrupt you. Was there anything else you would like to address and have the panel consider?
That is everything that I plan to say, Your Honor.
Okay, thank you. I'm going to ask Judge Donaghy if you have any questions for Attorney Goldstein.
I do not. Thank you.
All right, Chancellor Colbreth.
No, not at this point.
All right. Let me return to General Griffin then and ask if you have any rebuttal.
Thank you, Your Honor. My friend on the other side raised quite a few arguments about the implication or lack thereof of the amendment to the law that's being challenged in this case. Those are all arguments that could certainly be raised in response to a Rule 12 motion for judgment on the pleadings. But that doesn't, it's odd to us that the plaintiffs would have so many opinions and comments about how the amendment to the law should be interpreted or applied and not amend their complaint. But they've told the court again, they do not intend to amend their complaint. If we're wrong about that, I'd like them to make that clear. We don't want to be in the position of filing a Rule 12 motion and then having a motion to amend and then going through the whole process again. But Your Honor, these are all arguments that can certainly be raised in response to the Rule 12 motion. That only shows that their legal theories have changed. We're not really sure exactly what those legal theories are. We think it's improper to flesh out their new legal theories through expert reports or some other unknown discovery we don't yet know about. My friend on the other side mentioned that the plaintiffs don't think that the scope of discovery has changed, but even in response to the defendant's discovery requests, the plaintiffs have said that they refuse to provide any information about abortion practices from before the 2022 version of the law took effect, because that was an old law. And yet the law has now changed. We have different statutory language that physicians are bound by in Tennessee. And yet the plaintiffs want to move forward with discovery about the interpretation and application of an old law related to the medical exception. And that doesn't make a lot of sense to us. In fact, we think that, ignoring the fact that SB 1004 came into existence is extremely improper with respect to discovery. And so if
Improper in what way? You had a statute, the statute's been amended, discovery was propounded before the amendment. How does that render the discovery improper? I'm not following you. If you could explain that a little bit, please.
Sure, Your Honor. We're answering discovery about how doctors in Tennessee applied the medical necessity exception under the old language. The old language did not have the definitions that are included under the current statute or the examples of medical conditions where abortions would be permitted that the new law currently does. And so it seemed, and the plaintiffs appear to agree in the responses that they have sent us, that how an old law was interpreted or applied doesn't have a lot to do with how a current law is interpreted or applied. And so we are barreling down this road of very costly, very time-consuming discovery.
Well,
And Your
the
Honor,
new, the amendment, it's not a new law, it's an amendment to the existing statute, has been in effect less than 30 days.
correct, Your Honor.
And so I'm still not grasping your objection on the basis that the pending discovery is improper.
Well, the discovery,
It may be, you may suggest that it's no longer completely applicable or something, but the challenges remain the same. The three challenges to the statute in terms of their legal theories, the right to life claim, the equal protection claim, and the unconstitutionally vague claim. Those legal theories remain the same. So I just want to make sure, without getting into the merits, that I understand what your position is as to why continuing with current discovery is improper.
well, bottom line, Your Honor, is that there's nothing in the Second Amendment complaint that explains how the current law, as amended, denies any plaintiff in this case the right to life, especially with the language incorporated from this court's temporary injunction order. There's no allegations in the Second Amendment complaint how any plaintiff.
You're welcome to make your motion. I don't know that
Yes.
that.
And I didn't want to get into the merits argument, Your Honor. I was just trying to respond helpfully to your Honor's question. The bottom line is we intend to raise arguments in our Rule 12 motion. This court lacks subject matter jurisdiction, that the defendants are entitled to sovereign immunity, and that in the current posture of the case, if the defendants were forced to go forward with this discovery that's been propounded, or still to come, frankly, that would deny any sovereign immunity that the defendants are entitled to.
Mr. Griffin, I
yes,
have
ma'am.
a question. I have a question about that. And I understand that there has been a change in attorneys. I mean, I understand that the lead attorney is no longer with the state or in that capacity. But we've already held that sovereign immunity was waived under the statute and under Colonial Pipeline. The state did not ask for an interlocutory appeal, as Ms. Goldstein said. Why are we having this argument again?
Well, and since the court issued its ruling, there's been a new complaint filed, an amended complaint has been filed, and we're going to address all of this in our Rule 12
Which is
motion.
now the operative complaint. And it supplants, the prior complaint. So that we don't end up going down a wrong avenue here.
Mm-hmm.
And there's no issue regarding that. You have, as I understand it, the way things sit at the moment is you have invited the plaintiff, or at least inquired of plaintiff's counsel whether they wish to further amend their complaint. They have responded no. So it is your intent to file a motion to dismiss. That's where we find ourselves today at this status conference. And what you are requesting, as I understand it, is a schedule for briefing, for filing the motion and briefing on that motion. And you have suggested that you can file it by Tuesday of next week. So and you're going to couple that with a motion to amend the scheduling order, which we do not yet have before us. So we're not able to address that substantively today.
That's correct, Your Honor. We're
Okay,
primarily
that's where
requesting. we're
that's where we
requesting
find
guidance on-
ourselves. And I'm just trying to put some parameters around what we're actually here to address today. Is there anything else you would like for us to consider then?
Your Honor, the primary thing we're here today is to get guidance from the court on scheduling for the Rule 12 motion, as well as our forthcoming motion um, uh, to amend the scheduling order to stay proceedings.
All right. And let me ask Judge Donaghy and Chancellor Colbreth if they have anything else that they would like to clarify.
I don't.
Okay. All right. What I would like to do at this juncture is to allow the court to take a recess. And if you all are able to stand by, or Mr. Williamson, I don't know if you want to put them in a breakout room while the court is in recess, but we will take a recess and come back in just a few moments.
Attention everybody, the judges are ready. I will be bringing them in shortly. Chancellor, everybody is present. You may proceed once you're ready.
Very much, Mr. Williamson. And thanks to everyone for your patience as the panel conferred. We wanted to go ahead and address this issue quickly so that you have the guidance that you need in moving this case forward. Based on our discussion at the status conference, the panel has established the following deadlines. The state may file any Rule 12 motion by May 13, 2025. If the state files a Rule 12 motion by that date, they indicated they would also intend to file a motion to amend or stay the scheduling order. We would request that motion be filed at the same time. The plaintiffs, plural, may file their response to any motion that is filed on May the 13th by June 27th, 2025, which is 45 days later. And the state defendants may file a reply, if any, by July 11, 2025. Those are the only dates we are going to establish today. We are, just for clarity, since discovery was mentioned several times, we are not staying discovery today. Discovery should proceed under the current scheduling order. The panel also discussed potential hearing dates based on our calendars, which does not include, obviously, the parties' calendars, but we wanted to go ahead and offer. I'm not going to include these dates in the order that will be entered on the status conference today, but I want to give you some potential dates to determine availability. Those are July 25th and August 8th. Those are both Fridays. And we would suggest that those, that the hearing be conducted in person in Nashville on those dates, subject to everyone's availability. That's the court's determination on today's status conference. Judge Donaghy or Chancellor Colbreth, do you have anything to add?
No.
No.
All right. Let me ask counsel for the parties if they have any questions or if there's anything else we can address. Attorney Goldstein?
High school she doesn't have audio based on the chat, so I can say for plaintiffs that plaintiffs don't have any further issues to raise.
All right, very good. General Griffin.
Thank you, Your Honor. I just want to clarify, I understand that the court has provided deadlines for both the Rule 12 motion and our anticipated motion to stay discovery. We do anticipate filing a motion for expedited consideration of the motion to stay discovery. I just wanted to make sure that we wouldn't be prejudiced from doing so based on the court's deadlines given just now.
General Griffin, you can file whatever motions that you wish to file. And yeah, I can't rule, the panel cannot rule on any motions that have not yet been presented to us. So I have no comment to that. We will consider them if and when they are filed. The panel does reserve the right to rule on any motions that may be filed without hearing, to rule on the papers, because it is important that we keep this case moving. So I just want to put everyone on notice that we will reserve that right to rule on the papers without oral argument.
Thank you very much, Your Honor.
Anything else?
No, Your Honor.
I do,
Okay,
Chancellor Moskell,
Yes.
I do believe we spoke or at the very beginning, and I think it was in one of our breakout rooms, that we were going to allow YouTube viewing and that a link would be provided for any Zoom hearings in the future. So the attorneys are not going to need to request that. I think we're going to have that available. So we don't have to have Mr. Williamson scrambling like he
that
did
is
this.
correct. That is correct. And actually, the request that we received to live stream today's status conference came from a member of the public. And our goal is to make sure that the public has open access to the courts. And so just to put, we hadn't anticipated doing so on a status conference, but we are happy to do so. And so all hearings in this case, whether they are by Zoom or in person, we will make arrangements in advance to have them live streamed. And that live stream link will be posted on the court's website. Thank you, Chancellor Colbert. Anything else from plaintiffs or defendants? Mr. Tift?
Your Honor.
All right, General
Nothing
Griffin.
from the state. Thank you, Your Honor.
All right, this status conference is adjourned.
Have a
Thank
good
you
day.
all.